it'll be in future cases that that the boundaries will be pushed of exactly what the definition is of Métis. But the thrust of the legal argument is that we have to use principles of constitutional interpretation in deciding what a constitutional Indian is. We're not dealing with an Indian Act Indian. There had been an earlier case, the Blais decision from Saskatchewan, where the court, in that decision, the Saskatchewan Court of Appeal, didn't realize, the time it was hearing it, that the NRTA was constitutionalized. And that issue was revisited in Grumbo, and the Court of Appeal here admitted that it was an error in failing to recognize it was a constitutional document. The rules of constitutional interpretation is different from statutory interpretation. Unlike statutory interpretation, constitutional interpretation is, as Larry said, it's like a living and growing tree. It evolves with time. And so some of the errors committed, by the courts and the lower courts in the Blais case was that they used principles of statutory interpretation, not constitutional interpretation. And I think the biggest part of the argument is we have to look at the Constitution together. We can't just take an isolated piece. We have to look at the intention of the framers of the whole Constitution from 1867 to 1982. And what do we find? Well, I think it's obvious. You look at Section 37 and 37.1, which we heard about from the previous speakers, and how clear can the intention of Parliament and the provinces be when they expressly state under Section 37, and there's a little reprint on page 9 of my paper. It says, among other things, included on the Constitutional Conference agenda is, number 1, the identification of, and number 2, the definition of the rights of those peoples. So clearly, in 1982, they put in a constitutional provision that the Aboriginal people of Canada include the Indians, the Inuit, and the Métis, and that they recognize and affirm their Aboriginal and treaty rights, and they don't go on to define their Aboriginal treaty rights, and they don't go on and define the Métis people. But then they go on and to say, here's a process. Over the next 3 years or over the next 5 years, we're going to call in the Aboriginal leadership. We're going to call in the First Ministers. We're going to call in the Prime Minister. And we're going to sit around a round table and we're going to have on the agenda the identification of those rights and the definition of them. Well, what does that mean? I don't think you have to be a scholar to figure that out. It's obvious. They intended that the answer to all of this is that they wanted to make it known that the Métis are an Aboriginal people with Aboriginal rights, and there was no question of that, and it was a recognition of the thorny issues that existed, and of putting together a mechanism by which to solve them. Now, history shows that it wasn't solved, and the answer in our Canadian Canadian legal system is that if Parliament and the legislatures together can't resolve those questions of interpretation, then it's for the courts to interpret. And for Ernie Blais, being the president at the time of the Manitoba Métis Federation, how can you argue that he's not accepted as a member of the Métis people? There was genealogical evidence, which admitted by the Crown. He's descended of persons who received scrip. The judge found as a fact that he was Métis. And I submit that should be enough to determine that Ernie Blais is Métis within the constitutional definition, and that the Constitution includes the 1930 NRTA. The courts historically, when they make rulings, they try to restrict their ruling on the particular facts of the case. So clearly, when the decisions come out for both Pauli and Blais, they're not going to draft comprehensive definitions of anything. But it'll be for all of us to drive the future road to the definition and identification of those rights in whatever forms that could be. And nothing prevents the different levels of government and the leadership from getting together and looking at constitutional amendments in the future. And nothing prevents our people from lobbying and speaking out on, and letting the political leadership know what their rights are. Nothing prevents that. So we all have the ability, and often on thorny issues, whether in other fields of law, in addition to Aboriginal rights, often the issues are avoided, and when that happens, it ends up being the courts, through a series of decisions, that really identify and define what those are. So I think in reality the future for the identification of Métis and their rights lies probably to a good measure to future litigation. And in a way this might be unfortunate, because there should probably be a better process, but than letting the judges decide. But when there's no alternative, that's normally what happens. So it's probably going to be a long road, and after the Pauli and Blais decision, there's going to probably be more questions than answers given by the court. And the subject will be of a continuing debate for many years to come. And